the Indian Constitution.
My dear brother, friend and mentor, Justice Khalifullah, dignitaries on and off the dais, ladies and gentlemen, Vanakkam. Little do you realize how much I am a part of you. I am the great K.K. Venugopal's junior. And therefore, in that sense, a grandson of this great man. You see before you a somewhat older and somewhat balder version of what you saw on the screen. Not necessarily wiser. When I joined Mr. Venugopal's chamber, one of the very first things that he did to me was to give me the green notebooks of his father. And in my very first week there, I went through with increasing admiration the copious notes that this great man made for every case that he had to argue. The green notebooks contained the wisdom from overseas. There were a vast number of judgments from the United States Supreme Court which engaged his attention, quite apart from those of the House of Lords, Court of Appeal, Irish reports, Commonwealth reports, Dominion law reports, you name it and the list goes on. I realized then that I was actually sitting at the feet of a polymath, of an extremely brilliant, outstanding constitutional lawyer. And as you have heard, it is this great constitutional lawyer who introduced the concept of basic structure through the concept of implied limitations. Now, we need to go back a little and digress in order to come back to these words. If we begin at the beginning, we had in our Constituent Assembly persons who had before them the constitutions of the world. Since basic structure really begins with the Amendment Article 368, it is important that you know what Article 368 is first. And then we'll go back and see what were the models which were before the Constituent Assembly for them to ultimately come out with Article 368. Now, the very starting point of any doctrine of basic structure must begin with Article 368 for two reasons. The first reason is that the power to amend or change a constitution is one of the most important things which a flexible document like a constitution must contain if it is to ultimately reflect the felt need of the times. Second, 368's language is a little important. As it originally stood, it used two words. It used the word amend in the first part, and it used the word change in the second part. Now, what is important is that the word amend was used without the words by way of, let us say, variation, repeal, etc. And the word change was used in the proviso. The very first thing that strikes you on a bare reading of the article then is this, that if any amendment or change is made, the Constitution shall stand amended. Now, if it stands amended, obviously the Constitution as a Constitution must remain. Questions were asked repeatedly to counsel in Keshavananda Bharati's case. Can you repeal the Constitution without substituting anything in its place? The answer is a resounding no. Because though you may reach each and every article and change each and every article, something must be left behind. Because ultimately the constitution must remain, it must stand amended. This is one very important thing that you all must bear in mind. The second very important thing is that the word change used, so far as the proviso is concerned, again goes to or goes as far as substitution but doesn't go beyond. You may modify by way of change, you may even substitute by way of change. But the big question is, can you repeal without more by way of change? Now let me explain myself. As we said, the first part of 368 allows you to reach every part of the constitution and change it or amend it as it stood then. The second part is an enigmatic part. It's a proviso. And it deals with 5 different specified subject matters. And says that if you wish to deal with any of these subject matters by way of change, then not only does Parliament have to pass it, but it has to go for ratification of at least one half of the states. So we begin with 368, and you must bear in mind the important thing or the important 2 things that I have told you at the very outset, which is, number 1, you can't repeal the constitution as a whole. Something must remain behind. Now the immediate question is then, what is that something? Second, if the word change in the proviso goes as far as substitution but not repeal, again it's a pointer to something. And the pointer is something, the fact that they did not in fact represent the people of India. You will remember that under the 1935 Government of India Act, there were provinces in this country. And there were elections to the various houses in those provinces or the legislatures of those provinces, which elections under the schedules to the Government of India Act required adult voters to have something more than mere age on their side. It wasn't enough to be 18 or 21. You had also either to be a matriculate or to be an income tax payer or some other qualification. So what was important was that under the Government of India Act, persons who were elected representatives of the people, and mind you, this pertained only to the provinces and did not pertain to the princely states, because India at that time, if you remember, was governed by the doctrine of British paramountcy. You had paramountcy so far as the states were concerned, without more, and you had the provinces. And it is only the elected representatives of provinces who ultimately chose from among themselves who were to be members of this Constituent Assembly. And they were roughly 28% of the voter population, so to speak, because most of the voter population, even though adult, was left out because of the schedules that I spoke about. So I feel they were overwhelmed by this first. They felt that they did not truly represent, in that sense, the adult population of this country. Another very interesting thing, not only did they not represent the adult population of this country, they also felt that it would be better to leave a first parliament which would be actually elected by the adult franchise of this country to then set the constitution straight, so to speak. Another thing that was probably in the background of their minds was that they were really set up by a foreign statute. As you know, the Constituent Assembly was set up by the Section 8 of the Independence of India Act, which was passed by the British Parliament. Keeping all these things in view, they ultimately arrived at the compromise formula of Article 368. Now I'll tell you why it's a compromise formula. They had before them various world constitutions. They had the oldest living constitution of the world, which is the US. Article 5 of the US Constitution has a two-tier process. It begins with 2/3 of Congress, that is the two houses of Congress, proposing a constitutional amendment, which then needs to be ratified by three-fourths of the states. Now, this can be done in two methods. We are not concerned really with the method. One is constitutional convention, one is otherwise. But the importance is that a mere 2/3 of the houses of parliament, so to speak, in America, would not without more be able to touch any part of their constitution without a resounding 3/4 ratification from the states. Second, you actually had in Article 5 two things that could not be touched, that were put beyond the pale of the amending body, so to speak. One was the representation of the states in the Senate, which is equal to our Rajya Sabha. That you could not touch at all. So even if the states ratified it, out of bounds. And second, until the year 1808, you will remember that this constitution was ultimately ratified and became law in 1789, the year of the Bastille. Till 1808, you could not touch two provisions of Section 9 of Article 1, one of which dealt with immigration into the states and another dealt with representative taxation. So there were two express limitations in Article 5 which were beyond the amending power. This is a little important to keep in mind. Now, they had this model before them. They also had the model of the Commonwealth of Australia Act, which again was a British Act of Parliament passed in 1900, where if you wished to tinker with the Constitution, you had to go to the people. And it is only by a referendum that ultimately that Constitution could be amended. And please remember, because of the rigidity, inflexibility of these procedures, the US Constitution in 225 years has been amended 28 times. Only. The Commonwealth of Australia equally has been amended only 6 times. It's a 1900 constitution, so you can imagine we are in the year 2015. In 115 years, it has been amended only 6 times. Now, they had these two models before them. They also had a very interesting model in the 1922 Irish Constitution, which is the constitution just before the Free Irish State of Eire came into being, which they also had before them. But the 22 Constitution had something remarkable in it. It said, we opt for referendum if you want to touch this Constitution. But for the first 8 years, we will leave it to Parliament, the Oyer Cetas, as it is so called in Ireland, by simple majority to pass whatever amendment they want. So you had some kind of breathing time, breathing space. The framers of the Constitution realized, like our framers, that they didn't represent everybody. Let a Parliament come in. Let it by ordinary majority have a kind of removal of difficulties clause for 8 years. After which, you have to go to the people. Now, one of the interesting cases which arose in Ireland was Ryan's case. It's a 1935 judgment. And it was a sharply divided court, as most courts in all these matters are. It was 2-1, with the Chief Justice dissenting, that Ryan's case upheld the Oyer Cetas, that is the Parliament of Ireland, amending the provision which said it got only 8 years to make it 16 years. So, the Irish Parliament suddenly realized that, look, 8 years doesn't seem to be enough. Let's give ourselves another 8 years, where by simple majority, we can do what only the people can do, which is change the Constitution. 2-1, in 1935, Chief Justice Kennedy dissenting, the Irish Supreme Court held that, look, The Oerketas, when it amends the constitution, is acting as a constituent body. If it is acting as a constituent body, a court of law cannot go into any constitutional amendment that they wish to make, even if they wish to aggrandize their own power. So 2-1, you had the opposite of Keshavananda Bharati in 1935 in Ireland. All this was before the founding fathers and more. Now, why did they choose 368 in its present form? Please remember, what Article 368, shorn of the proviso, which deals with certain specified subjects, requires is a mere 2/3 majority in the Lok Sabha and the Rajya Sabha to tinker with any part of the constitution. And what is important is that 2/3 is not the total strength of the House. It is 2/3 of those present and voting. So it makes it very easy. Subject, of course, to your having a simple majority. I mean, obviously, the government of the day would have a simple majority. So subject to is something that is said ex abundanti cautela. So long as you have 2/3 of each house with you, present and voting, you can do what you like to our constitution. On the other hand, under Article 61, the same constituent assembly, when it came to impeaching the president, said you require 2/3 of the entire strength of both houses. Now, why did they do this? I kept asking myself. The answer is obvious. They felt overwhelmed by a sense of their own inadequacy. They had Ryan's judgment staring them in the face. And they felt that, look, it may not be possible for ourselves to give ourselves a moratorium period and say, allow the first parliament, let's say for the first 5 years, to do what it likes. So, the compromise formula was chosen. Incidentally, there was a draft Article 305 also, which dealt with representation of minorities, scheduled castes, etc. in Parliament. And it was proposed that draft article should not be touched even by constitutional amendment, like Article 5, if you remember, of the US Constitution, for a period of 10 years. That proposal was dropped. So ultimately, you had this compromise formula of 2/3 majority present and voting without ratification by three-fourths of the states. So they picked up one part of Article 5 of the US Constitution, dropped the other part. Now, so far as the proviso is concerned, it's a little interesting to know there are subjects which don't seem to make much sense, except to say that the states should be interested in this for such constitutional amendments to go for ratification. The first part of the proviso speaks of the articles dealing with elections to the presidency. So if you want to touch elections to the presidency, where the states have a vital role to play, you have to go to the states for ratification. Equally, if you want to touch the executive power, which is contained in 73, so far as the union is concerned, and 162, so far as the states are concerned, again you have to go to the states. Because if you want to increase or decrease one at the cost of the other, the states are concerned. In the second, which is most important, if you want to tinker with the judiciary at all, whether it is the High Court, Subordinate Court, Supreme Court, again you have to go for ratification. Third, if you want to tinker with the legislative lists, you will remember that we have a Schedule 7 in our Constitution. And the legislative making, so to speak, is distributed between the center and the states in 3 lists. You have an exclusive list for the union, exclusive for the state, and a concurrent list. Equally, you want to tinker with any of the entries in those lists, please go to the states for ratification. Fourth, states' representation in parliament. Again, states are directly concerned. You wish to tinker with that, again you go to the states. And fifth, and very interesting, any amendment of the amendment article itself. So, If you want to touch 368, again you can touch it only if you go to the states for ratification. These are the 5 things in the proviso. Now, with this little background, we come back to our constitutional history, some of which has been put before you by my predecessor speakers. So when you began, you had this compromise formula in 368 by which 100 amendments have been passed now in the space of 65 years, because you wanted this constitution to be more flexible. You didn't want it to be as rigid as the older ones, for the very good 2 reasons that I gave you earlier. Very early in our history, one of the most important things that was sought to be pushed through, and this in fact distinguishes us from Pakistan, was the land reforms program. And early challenges were made to land reform laws in 3 high courts. You had the Patna High Court, which struck down large parts of the Bihar Land Reforms Act, which is why it is entry 1 in Schedule 9. And you had 2 other high courts, Allahabad and Nagpur, which upheld the respective land reform statutes. The new parliament was in a great hurry. It couldn't wait till the Supreme Court said something about these judgments. So it pushed through what is called our First Amendment. And among other things that were done, it was a very large amendment dealing with a number of subjects. It introduced for the first time Articles 31 capital A and Article 31 capital B. Now 31A, we can understand that, look, basically you want to see that property rights do not come in the way of an agrarian reform program. So you say that we will not have any property challenge, which is basically under Articles 19 and 31, read with 14 because equality is usually an adjunct. And we will not tolerate such challenges so far as a specified subject matter, agrarian reform, is concerned. No problem. But added to that, you had something like a lawnmower to mow down a little gnat, which was 31B. 31B was wholly unnecessary. And you remember that it was added only because the then Advocate General of Madras wrote a letter in which he felt that it would be better that certain laws be put beyond the pale of fundamental rights altogether. Now 31B has two features which are way, way, way beyond 31A. You remember 31A dealt only with agrarian reform and it dealt only with property rights. 14, 19, 31. 31B suddenly said that if we put something into the 9th schedule, something we have passed, the legislature has passed, and it can be the central legislature, it can be the state legislature. The moment we put it in that schedule, it is free from harm, so to speak, and cannot be touched by any fundamental right. So the first important difference is that whereas 31A dealt only with property rights, 31B dealt with the entire panoply of fundamental rights. Everything went out of the window if an act was put in the 9th schedule. Second, and even more disturbing, was the fact that if a High Court or a Supreme Court, even the Supreme Court, had struck down a certain provision, and you were then to insert the act into the schedule, without more, that struck down provision would again resuscitate itself. Now, given these two features of 31B, a challenge was made in Sri Shankari Prasad Singh's case, which, as Justice Khalifullah told you, was reported in AIR 1951 Supreme Court. And a number of points were taken. We are concerned with only one point really. And that one point is whether Article 13, which is another article that I will come to in a minute, would include within it a constituent law as opposed to an ordinary law. Again, let me explain myself. Unlike the US Constitution, Article 13 was put into our constitution to set at rest once and for all the controversy which raged in the US, starting from Marbury's case, as to whether there could be judicial review of legislation. Now, our Article 13(2), with which we are directly concerned, says that no state shall make a law in violation of a fundamental right. And if such law violates a fundamental right, it will be declared by a court to be void. So Article 13 was an express provision in our constitution which spoke of states making laws. Please remember, the word make is a little important because it takes you straight to Article 245, which again speaks of Parliament making laws. The same phraseology is used. But the contention put forward before Justice Patanjali Shastri, as he then was, and who delivered the judgment in Shankari Prasad, that don't look at it textually. 13 should be read so as to include laws which amend the constitution as well. Because the idea is fundamental rights are inalienable rights. We have just had World War II before us. We've just had the Weimar Constitution trampled by foot by Hitler. And we have just had the new German Constitution, which makes them something which legislatures now can't touch. The argument was turned down. And on a textual reading of Article 13, a constitution bench of 5 judges held that Article 13 would go only to ordinary laws, so to speak, that is, laws made by the legislature, and not laws which amended the constitution. So Article 31B, that extremely draconian provision, passed muster. Things went on like this for another 15 years, until a large number of agrarian reform laws had now populated the 9th schedule. And the 17th Amendment added a few more, which then became the subject matter of challenge in Sajjan Singh's case, which Justice Khalifullah spoke about. Now, this is in 1965, so a period of 14 years have passed now. And again, this same ground was revisited. This time, another constitution bench followed Sajjan Singh, said Article 13 does not go to constitutional law, but with a difference. The difference was only this. 2 learned judges, Justices Hidayatullah and Justice Mudolkar, expressed doubts for the first time. And they said, look, we need a larger bench to get into this because we are not sure as to whether constitutional laws do or do not come within Article 13. Justice Mudolkar went much further and, being a visionary, actually used the words basic structure in his judgment for the first time. And in a very interesting paragraph, tells us for the first time, is there something like a basic structure to this constitution which cannot be touched at all? Given this, we now have the 11-judge bench of Golaknath in 1967, headed by Chief Justice Subbarao. Again, by a fractured majority, because we have 5 speaking against 5, with Justice Hidayatullah there as the odd man out. 5, Chief Justice Subbarao leading, said 2 things. One, that the power to amend does not occur in Article 368. Why? The marginal note to the article reads, procedure for amendment. So therefore, we will look at that marginal note. The marginal note tells us the drift of the section or the article. And therefore, it is only the procedure, namely 2/3 ratification by half, that is spoken of. The power to amend is located elsewhere. And the power to amend, according to Chief Justice Subbarao and 4 other learned judges, since it wasn't expressly located anywhere, would fall within the residuary article. And therefore, Parliament could amend under the residuary article. 5 other learned judges said no. Article 368 occurs in a chapter by itself, chapter 20. Why should it have a chapter devoted to itself unless it dealt with the be-all and end-all of amendment? So, everything must be found only in 368. The odd man out, Justice Hidayatullah, said, no, this power is sui generis, Latin expression, which means something of its own. So we leave it there. We don't say that we find it either in 245 or we find it anywhere in the Constitution. The reason being that ultimately this is a Constitution which, in order to be flexible, has to be changed. So you have to find it as a necessary concomitant of a Constitution which has to change. The other point on which there was, again, a very sharp cleavage, and this time Justice Hidayatullah tilted the balance on Chief Justice Subbarao's side, that Article 13 would go to a constitutional law. And therefore they said that, look, you can utilize 368, you can amend any provision of the Constitution, but you cannot touch fundamental rights. Because fundamental rights are inalienable, they are human rights. There is this UN Convention of 48, etc., etc. You can't touch. This being the case, Parliament was swift now to act. As you heard from Justice Khalifullah, they enacted the 24th Amendment in 1971. The 24th Amendment sought to do away with both the props on which Golaknath's case stood. Prop number 1, Article 368 was amended, stating that the power to amend now is directly in that article and nowhere else. And second, Article 13 goes only to ordinary law, does not go to constitutional. Then you had a 25th Amendment passed in the same year, dealing with property rights with which we are not concerned in this lecture, and adding for the first time an Article 31 capital C. Now you remember 31 capital A dealt with agrarian reform and kept the property rights out of agrarian reform, so that if your challenge was based on a property right, the challenge would have to be dismissed without more. 31C now was introduced, keeping in mind somebody else's vision. This is another very interesting vision. Shri B.N. Rao, who was one of our first judges who went to the International Court, was constitutional advisor to the Constituent Assembly and came out with a draft constitution. It was always his view that directive principles should have precedence over fundamental rights. Now, directive principles are in a separate chapter, borrowed again from the fresh or the new Constitution of 1946 of Ireland. Interestingly enough, the Irish Constitution was a Catholic Constitution. It was not a secular Constitution. And the directive principles that formed particularly parts of our 39B and C went back to papal bulls. That is, a papal bull is something which is like an order which is issued by the Pope sitting in Rome. And 39B and C are supposed to go back to Pope Innocent III, who was very famous in history for one other act. He nullified Magna Carta the moment it was made. Now, we are in the 800th year of Magna Carta. It was 1215. As soon as King John was forced to sign it by the barons, the Pope there nullified it. Now, this same Pope came out with our Articles 39B and C. So, it was borrowed from a Catholic constitution and shoved into a secular constitution. It's a very interesting thing. And 39B and C tell us what? They only tell us that the material resources of the community shall be so distributed as best to subserve the common good. Socialism at its highest. The people, for the people, everything for the people. And the concentration of wealth shall not be in the hands of a few to the detriment of the many. So, these two sub-articles, which come from a papal bull, 800 years old, were picked up and put over fundamental rights. Again, property rights. Because the same articles that were used in 31A were used in 31C, 14, 19, 31. And this is what prompted Justice Khanna, the odd man out in Keshavananda, just as Justice Hidayatullah was the odd man out in Golaknath, to say that I uphold this article only because it deals with property rights. And according to me, property rights, they may be fundamental, but they do not pertain to basic structure. So based on a vision of one particular judge, ultimately 31C passed muster. And this sets the stage for Keshavananda Bharati itself. Now in Keshavananda Bharati, as you were told by Justice Khalifullah, 4 amendments were the subject matter of challenge. 24, 25, 26, 29. 26 took away privy purse that was kept by 13 judges to be decided by a future bench. So 26 went out of harm's way. 24, 25 and 29 were deliberated upon. 24, you will remember, was the undoing of Golaknath. Nobody, not even the majority, seriously felt that Golaknath was correct. So the undoing of Golaknath was an easy task. No problem. But then what happens to Article 31C, which was the bone of contention? And there again, there was this sharp cleavage, just as you had in Golaknath. This time you had 6 against 6, with Justice Khanna as the odd man out. And the odd man out had one particular vision, which was that property rights are no part of any basic structure. They may have occurred in the US Constitution in Article 5 together with life and liberty. But in this country, we must segregate the two. And since property rights are no part of basic structure, even though I believe in basic structure, I will not strike down 31C. So 31C then passed muster by this narrow one vote. The second part, as you know, which said that no court will go into it, was struck down by. So we come back now to what is basic structure. Because the great Mr. Nambiar's argument, and he was always ahead of his time, because whenever he argued something, he usually lost, but that argument was ultimately picked up, and a future court found the wisdom of what he said and decided in accordance with what he said. This time, 7 judges went back to Justice Mudolkar and found, yes, there is such a thing as a basic structure. And different judgments spoke of different features as being essential, basic, etc. So we come back to now, what exactly is a basic structure? There are 2 interesting visions which compete with each other. One is the vision of Justice Matthew in Indira Gandhi's case, which Justice Khalifullah spoke about. And one is Justice Krishna Iyer's in Bhim Singh Ji's case of 1981, which dealt with a 9th schedule challenge. Justice Matthew felt that you must find the basic structure rooted in some article in the Constitution. It's not a principle hovering around like supremacy of the Constitution. It must find its place somewhere. Justice Krishna, on the other hand, said, no. When we speak of the great egalitarian principle, we are not speaking of Article 14. We are speaking of a principle. And that principle is what forms part of the basic structure. Article 14 doesn't. This debate has continued till date without much clarity. So, where does basic structure actually reside? I think we get clues from the preamble and from Article 368. Now, the preamble, you will remember, even though it's a preamble, it's the very beginning of the Constitution, was actually drafted at the end of the draft Constitution. Therefore, the framers really summarized what they thought were the principles that this constitution laid down. And from it, you can cull out about 6 principles which one could call principles which really pertain to the basic structure. You have the first words. You have the fact that India is a sovereign democratic republic. Each word has in it a essential feature. The fact that it is sovereign goes along with the fact that the country is one, unity and integrity, which is the last part of the preamble. So you put the two together, and what do you have? You have the fact that India today governs itself. It has thrown off a foreign yoke. So in that sense, it is sovereign. Second, it has chosen the democratic form of government. The democratic form of government believes in universal adult franchise, so that your representatives who govern you are persons who truly represent the adult population of the nation. What is the adult population of the nation is a separate matter. It was 21 years at the time of the Constitution, it is 18 years now, may become 16 years later. But the fact that we adult Indians rule ourselves is another essential feature. Third, the fact that we are a republic. A republic, again, is to say that we are not a dictatorship, we are not a monarchy. So, we are ruled by what may be called republican principles, closely allied to democratic ones. Here, of course, we have a president at the head. And as you all know, after Shamsher Singh, the president basically has very limited powers like the English king. We are governed really by a cabinet which ultimately is put in by the elected representatives who we as adult Indians vote in. So you have 3 concepts: sovereign, democratic, republic. You have 2 other concepts added by the 42nd Amendment of Mrs. Gandhi. Socialist, secular. According to me, they were wholly unnecessary. They were already there. Because the very next clause speaks of justice, social, economic, political. Social justice gives you a clue that we are a socialistic state. And therefore, every time the legislatures make laws, they will look to the welfare of the people generally, they will look to the directive principles and then make those laws. So socialism is part of social justice. Secularism equally is part of the next clause. Now the next clause is nothing more and nothing less than the cry of the French Revolution. Liberté, égalité, fraternité. And all 3 are mentioned in the preamble. So, you have liberty, which speaks of the liberty to express yourself, to think as you wish, and above all, of belief, faith, and worship. If you already have the liberty of belief, faith, worship, you are a secular state. Because the obverse of an individual having this great belief given to him as a fundamental right is that the state shall not interfere with it. Neither shall the state, as a concomitant, help one religion against the other. In fact, hands are off altogether. So you have socialist, secular inbuilt already. It was unnecessary, as I said earlier. Liberty is very important because it brings in individual rights. Because not only is liberty of faith, worship, etc., it is also of expression of thought in the most fundamental sense. So, you have both directive principles brought in by the preamble and fundamental rights brought in. We have not heard anything about property. In fact, Justice Hidayatullah, being the odd man out in Golaknath, thought it was a mistake to include property in the fundamental rights chapter at all. And it is his vision which was translated into action 11 years later by the Janta government by removing it and putting it in a separate article. Then we have a very important concept of fraternity. So we believe in unity in diversity, very important. Now I cannot be fraternal with you unless I know what you are all about. Very difficult. So it preserves cultural rights. You will find Article 29 of our Constitution is one of the few articles which doesn't find place in most other world constitutions. The right not only to preserve language, but the right to preserve culture. And it's an absolute right. State won't tinker with it, can't tinker with it. So it becomes very important now to realize that unity in diversity is equally, if I may put it that way, a part of an essential feature or the basic structure of the Constitution. And ultimately you end with dignity of the individual, which read with liberty, again brings in the fundamental rights chapter. Divorce from property. So we have counted something like 6 or 7 essential features already from the preamble. If we go to Article 368 proviso, 3 or 4 more now come into being. The proviso speaks specifically of, as I told you, the executive power separated from legislative power, separated from the judiciary. And if you want to touch any of these, please go for ratification to the states. So you have separation of power which comes out of 3 of the sub-articles. You have independence of judiciary coming out of one of them, because if you wish to touch any part of the judiciary, as I have told you earlier, by amendment, you have to go again for ratification to the states. So you have separation of powers which has now emerged. You have independence of judiciary which has emerged. Then again, you have federalism which emerges. Because the moment states' representation in parliament is to be spoken of, or in any way, the legislative lists are tinkered with, which either curtail or add to state powers, you are touching a federalist issue. And last but by no means the least, the fact that you may amend the Constitution. And if you wish to change the manner of amendment, again you have to go to the states. Now, we have been able to cull out something like 11. My mathematics has never been good. 11 or 12 essential features from just a reading of the preamble and 368 proviso. We come back to the same conundrum posed. One by Justice Matthew on this side and one by Justice Krishnayar on the other. Are all these concepts somewhere in the air, or are they all grounded in the Constitution? According to me, they are grounded in the Constitution, but we must always remember that it is a Constitution that we are expounding. Chief Justice Marshall's most important words in McCulloch and Maryland. Never forget, we are interpreting a fundamental document, fundamental in all our lives. So principles of interpretation which apply to this document will be completely different from ordinary principles of statutory interpretation. Now, if we bear that in mind, and if we realize that we are not to be in the bark of words, so to speak, but that words themselves yield principles, then I don't think we have any difficulty in reconciling these two visions. You reconcile them by saying, yes, it has to be somewhere in the Constitution. It need not be in one article, it need not be in a sub-article, it may be in a cluster of articles, it may be at one end read with the other end. But ultimately, what you find from the words is principles. And if what you find is principles, then we have no difficulty. So if ultimately you wish to tinker with a principle, let us say of independence of judiciary, you will find it grounded in chapter 4 of part 5, which deals with the higher judiciary. You may find it grounded in 235 onwards, which deals with the high courts and the subordinate judiciary. So ultimately, you have to ground yourself in some article or cluster of articles. And if you so do, then an essential feature emerges from principles. And if you want to tinker with any part of that essential feature, please beware. Keshavananda stares you in the face. Now, the other problem is, suppose you have something which does not or cannot be found in some article. Justice Khalifullah referred to supremacy of the Constitution. Where do we get this concept from? Not the Constitution itself. We get it from the fact that it is a Grundnorm, it's a basic document, and from the fact that it is above all laws. Please remember, the US Constitution has this grounded in it, Article 6, Roman Article 6, which says that the Constitution and the laws made under it shall be the supreme law of the land. We don't have any such article. So possibly, basic structure is to be found not merely in articles, clusters of articles, but principles which can not only be culled out from the articles themselves, but also from concepts which are so obvious that somebody would say, of course, there's no question that the Constitution is supreme. So here now you have a third test. Now we come to the case law which followed after Keshavananda Bharati. You remember, we've stopped midstream, so to speak, case law-wise. We started with Shankari Prasad. We went on to Sajjan Singh, the doubts of two learned judges, Golaknath, the overruling of Golaknath, and then Keshavananda. Post Keshavananda, virtually the first case that came up was the Indira Gandhi election case. And something remarkable was done by the addition of the new Article 329 capital A. The Prime Minister and the Speaker, in simple words, were put above the law. In short, if there was a Prime Ministerial election or a Speaker's election, not only could no court go into it, but if a court had gone into it, no law was now to be applied in appeal. And 5 judges were unanimous in using basic structure to strike it down, though on very different visions. Chief Justice Ray's vision was perhaps the widest vision so far as the constituent body is concerned. He said, yes, constituent body is above Parliament, above the Supreme Court, above everything, above all the organs of the state, and can pretty much do as it wants. But ultimately, if it is going to set aside a judgment, which it can do, it has to apply law. And here, it was applying nothing. So therefore, according to the learned Chief Justice, the rule of law concept comes in. There was no law to be applied. Amendment bad, therefore, and violates an essential feature. The second learned judge, Justice Khanna, found that it went at the heart of democracy. Why? Because the concept of free and fair elections had been invaded. You put 2 persons up above the law, and however unfair, whatever that election result, it must be upheld. So he went on democratic principle ground. Justice Matthew fundamentally went on the ground that a constituent body, though sui generis, is not something which is equipped to decide cases. And in a very interesting footnote given, which all of you should read, he describes a bill of attainder which was passed, which was one of the last bills of attainder, passed against a man called Fenwick in 1696. And what he says is that a bill of attainder is like a legislative judgment. all the legislators sit as judges. The accused is put in the dock, charges are read out to him, and then he puts his defense before them. And he describes the scene, what happened in Fenwick's trial. Poor Fenwick was putting something forward. People were chatting among themselves, not listening to him. People say, legislators walking in, walking out. In short, his judges just didn't bother about him. And the poor man was put to death. And that was perhaps one of the last bills of attainder ever passed. Which is why the US Constitution, which followed 100 years later, expressly said no bill of attainder or ex post facto law will be passed by Congress. So Justice Matthew went on the principle that a constituent body, though above the organs of the state, is not equipped to deal with persons, individuals, and pass judgment. It was a separation of powers doctrine, in short, which he used to strike down the amendment. Justice Chandrachud picked up Article 14 and said the equality principle has been infringed without more. You have picked up two persons and put them above the law. There's no intelligible differentia between Prime Minister, Speaker, and any other elected person. And you have said, so far as they are concerned, no problem. Everything passes muster. So far as the other is concerned, you have an election code which has to be followed. Justice Beg did not say very much about basic structure, but also felt that if he read the amendment in a particular way, then actually the Prime Minister and the Speaker would have to face a proper trial and would ultimately have to have an appeal decided in accordance with law. So the first judgment post Keshavananda yielded some very, very remarkable fruit. You already had 5 different visions and 5 different features called basic. What followed upon the heels of this was, as Justice Khalifullah pointed out to you, the great Minerva Mills judgment. Now here, I must give you a personal note. Mr. Dadachandji, who is no longer alive, walked in just after I had graduated as a law student and presented the Minerva brief to me and said, look, you will be the only junior of Mr. Nani Palkhiwala in this matter, because it's not a paying matter. He is going to stay in Tata House, and we have picked up this petition because there are a number of petitions, we could pick any one up, in order now to get 2 pernicious parts of the emergency amendment, that is the 42nd amendment, done away with. Ambassador Palkhiwala, as he then was in the US, had promised the nation in speech after speech that whatever the Janta government could not undo, he would as a lawyer undo. So, what was not undone by the 44th amendment was 2 very important aspects, constitutionally speaking. One was the overruling of the basic structure theory in Articles 368, 4 and 5, which basically said there is nothing like a basic structure and Parliament cannot touch a constitutional amendment. Sorry? I'm sorry, court could not touch. So whatever Parliament said was final. Second, 31C then got fleshed out into not merely property rights, which were contained in 39B and C, but all the directive principles. So that now, the moment there was some law which you could, in some way, attach to a directive principle, out went Articles 14, 19, and 31. So he came to court to challenge what was left of the 42nd Amendment. And he succeeded in that challenge. All 5 judges struck down 368, 4 and 5, though you will find a slight difference in their reasoning. Justice Bhagwati's reasoning was that 368, 4 and 5 now prevent a court from going into whether an amendment is procedurally bad as well. And what he said was, suppose Article 53 were to be amended. 53 falls straight within the proviso to Article 368 and would require ratification. Suppose the President signs a bill without ratification, then what? So he said, on the ground that we can't even touch a constitutional amendment for not following the Constitution, this provision is bad. Chief Justice Chandrachud said no, went the whole way and said, Keshavananda has laid down as a principle that there is a basic structure. That principle must be followed. This violates that principle, therefore bad. And 31C again, there was a cleavage. Justice Bhagwati was in the minority there because he felt that if 31A were valid and 31C as originally enacted was valid, this was a logical extension of the two. But fortunately for us, Chief Justice Chandrachud and 3 other learned judges cried halt at this point. And they said that 14 and 19 are 2 parts of what they describe picturesquely as a golden triangle. The third being Article 21. And they said if 2 sides of this golden triangle were sought to be robbed of their efficacy, so far as a large number of laws were concerned, Constitution, therefore, would be affected and Article 31(3) as amended would not pass muster. Another very important thing that Justice Chandrachud, Chief Justice Chandrachud as he was at that time laid down in Minerva Mills, was the fact that not only had basic structure come to stay, but that fundamental rights were a means to achieving the ends that were stated in the directive principles. Both were of equal importance. So you cannot now ride roughshod over the means, however laudable the end. Post-Minerva, we have again had a series of judgments. The very first was Vaman Rao, in which 31A, B and C, as originally drafted, were under challenge. They were all upheld, subject to only one rider, again laid down by Chief Justice Chandrachud, that post 24th April 1973, which is the date of Keshavananda Bharti, Parliament has no business to keep populating the 9th schedule with laws. And if it continues to populate those laws, every such amendment will be liable now to be tested on the ground that it violates basic structure. The third is a very interesting judgment in the trilogy of Minerva Mills and second Vaman Rao. That is the case which goes by the name Bhim Singh Ji. That raised squarely raised a challenge to the Urban Land Ceiling Act being put into the 9th schedule. All 5 judges were agreed that one innocuous property section should be struck down. This is what is of great interest. That section was 27(1) of the Urban Land Ceiling Act. And all that section said was that if you wish to transfer urban land within a period of 10 years, you have to take the permission of a competent authority to do so. All 5 felt it was bad. Unfortunately, we have no reasons from 3 of them. Chief Justice Chandrachud agreed with Justice Krishna Iyer at the fag end of his tenure, and Justice Krishna Iyer signed a short judgment at the fag end of his tenure, in which he agreed with Chief Justice Chandrachud. And both of them agreed that 27 would be struck down but gave no reasons. So for reasons, we have to go to the minority. Justices Tulsapurkar and A.P. Sen. Justice A.P. Sen used a property argument as being part of basic structure, which Justice Khanna said you can't use. And Justice Tulsapurkar used Article 14. So again we come back to square one. Nobody knows how that section was really struck down. And post that judgment then, we have also had a couple of judgments in which the concept of judicial review, which emerges from, as you were told, Dr. Ambedkar's favorite article, 32, and 226 and 227. And various amendments, one in Sambamurthy, Article 371D. And in Chandrakumar in 1997, where again a part of the 42nd Amendment was struck down to say that Article 323B, which spoke now of tribunals substituting high courts under 226 and 227, would be bad. So we have one more concept which is now firmly embedded in our law, that judicial review now is also part of the basic structure of our constitution. And then finally, we have Coelho. Now, Coelho was meant to clear up some loose knots that were left by the holy trilogy that I spoke of, which is Minerva Mills, Vaman Rao, and Bhim Singh Ji. What it did was to create other problems. Because though it recognized the fact that fundamental rights are part of basic structure, it went on to have a two-tier test and said that the first thing that you must ask is, does a particular statute violate a particular fundamental right? If the answer is yes, you go to the second test. The second test then is, does it violate basic structure? Now, if fundamental rights are already part of the basic structure, where's the question of there being a second test? So we are left just now with various loose strands. And ultimately today, if you ask me, where is the basic structure doctrine, I would probably answer by saying it is probably where the elephant is with the 6 blind men. Each one will describe it from his point of view, but it requires some light and some sight, both, for us ultimately to see the elephant. And with that, I end this talk and hope that at some point there is light and sight. Thank you very much.